Hello everyone. Today we have a very interesting topic, that is Information Technology Act 2000, its purpose, object and the applicability. Actually, this is the first topic of your syllabus of BALLB honors 19th semester, where you have to study the information technology law. Earlier it was a cyber law, but the Department of Law, Aligarh Muslim University, changed the name of the subject, and now it is Information Technology Act 2000. The new communication system and the digital technology has made a dramatic changes in the way we live and the means to transact our daily business. This is what happened by the advent of information technology. Let us take an example. Suppose for transactions we are using the Paytm, the Google Pay. While booking the ticket, we are using the IRCTC website. So what happens in it? We are using the technology with the use of internet, or even while you are paying, you are using the UPI. So you must see that how your life has been changed by the use of these online transactions. Similarly, you may take other example, for example, e-commerce. When you have to purchase something, for example, you are going to purchase the laptop, the mobile, then certainly you will jump over the website called the Flipkart or Amazon or Paytm, Snapdeal. There are various e-commerce websites from where you can purchase the things. And since now you are relying much more over these websites than the physical stores. Similarly, for the uploading the contents over the YouTube, or suppose you have written an article and you are uploading over the, or you are sending the editor and he will publish the article over the online journal. Similarly, if you have a Microsoft account, or if you want to use the product issued by the Microsoft, for example, the PowerPoint or the Microsoft Word. So now if you're going to use the latest version of the Microsoft, then you have to use it online in online mode, and you have to be you should have ID and password which can run over the Microsoft. Similarly, the in case of personal conversation, you are totally dependent over the online mode. Nobody is going to send the what we call the chitti or the letter. Nowadays, what basically we are doing, we are calling the person, we are sending the SMSs, we are sending the emails in case of official communication, or in case of informal or formal communication, we are using the WhatsApp. WhatsApp is widely used, and now it is called the WhatsApp University, because very much fake news are being uploaded over the WhatsApp and circulated among the people. Similarly, for the social relationship, we are using the Instagram, we are using the Facebook, and even for the personal interaction, some people using the dating apps which are available in the cyberspace. Let us take the example of devices. So when we are using the computer, a smartphone, MacBook, laptop, Chromebook, a Chromebook is the latest version of invented by the launched by the Google, where the Chrome operating system has been launched by the Google. So we are totally dependent over the these information technology, and not only on these devices, rather we are dependent over the internet. So computer plus internet, the devices, even your smartphone is a computer, your MacBook is a computer, your laptop is a computer. So the basically these are the information technology devices, and devices plus internet is equal to cyberspace. You must keep in your mind, devices means here computer plus internet is equal to cyberspace, and it has no boundary, whereas in case of physical space there is boundary. We know what is the radius of the earth, but we don't know what is the radius of the cyberspace. Now, if we take another example called e-governance, even nowadays that our Prime Minister, Honorable Prime Minister, launched a campaign called Digital India. So basically, most of the things we are doing with the government, and that is through online mode. For example, you are filing an application for the ration card, you are filing an application for the income certificate, you are filing an application for the death certificate, marriage certificate, your driving license. So whatever the application you are filing for the to be issued from the government side, that all being filed through the Sahaj Jan Seva Kendra (CSC) Common Service Center. From there, in every village there are 2 3 CSCs, and where you are going and you are filing these applications. And they basically, in case of e-governance, there is direct communication between the government and the citizen, and therefore whatever the benefits are made, or whatever the policies are being made by the government, it is directly reaches to the citizen, and there is no intermediary. Or if you are going to take the ration from the ration card shop, then what happens, you are putting your thumb impression, then only the ration would be credited to you, or credited into your account, and then only he will physically hand over to you the ration, the rice. Similarly, now after the pandemic, COVID-19 pandemic, e-courts. Earlier, e-courts was not a reality, but now the e-court is now a reality. Even the Supreme Court and the various high courts are working over the e-courts. Earlier, we were understanding that e-courts means the uploading the daily proceedings over the website of the Supreme Court or the high courts and the district courts. But now, not only the proceedings are being uploaded, rather there is virtual proceeding. The advocates are appearing virtually from their home, and judges are also appearing in the court, sitting in the court as a presiding officer virtually, and there is a hearing, there is virtual proceeding in the courts. So due to this COVID-19, even e-courts has become the reality. Now come to the point, the personal relations are being made on the internet. For example, study.com, and there are many matrimonial websites like Urdu Matrimony. There are various websites where the person are meeting with each other, and they are making a personal relation, and now it is end up with the marriage. Again, these are the some positive aspects of the information technology, and which affects our daily life, that how we are going to transact with the people, how we are going to do our business, e-commerce, traveling, communication. So even the transaction with the business, transaction with the government, all are being affected very much with the information technology. But not only these positive aspects, there are various negative aspects of the information technology. For example, the crime rate has become very high by the by the information, by the data given by the National Crime Record Bureau. For example, the reputation of the person can be tarnished. Anyone can upload the morphed photograph of a woman over the website, and her reputation can be tarnished. Or vice versa, anyone reputation can be built up over the social media by portraying him that he is like a god. For example, Asaram Bapu, earlier he was like a god man, but now his reputation, but now he has been convicted for the offense of rape. Robbery, bank robbery. Earlier, the robbery was like a like a crime. It was like a physical crime, but now, if a person wanted to loot a bank, then in such a situation, he can hack the website of the bank, and he may rob the bank. But it is not a very easy, rather it's a very difficult to rob a bank. But nowadays there is banking frauds with the individual, like phishing, terrorism, data theft. So there are many crimes which are increasing day by day due to advent of information technology. So these are the some examples of the how our information technology affecting us very much. So if these things are affecting our daily life, then whether we need any some sort of regulation, is there any need of regulation? Yes, certainly we need regulation, otherwise our daily life will become hell. For example, if we are transacting with the person and if he is saying that we don't have any information, we don't have any storage, we don't have any record, then definitely there will be injustice caused to the other party. So there is need of some sort of regulation. Now, come to the point, need of information technology law. What happens? The businessman in their daily transaction, they are creating, transmitting the information with the other party, and instead of paper-based system, they are using the electronic-based system. But still, there is some sort of fear in their mind that if there is no regulation, then how this relationship would be built. To create, to transmit, and to store the information, it's very easy to store, it's very cheaper, and it's a speedier to communicate among the people. So therefore it's very useful for the business purpose, as well as we have seen that what are the various things which affects our daily life. So it's very easy to store and also to communicate. Although the people are aware about the electronic communication or the information technology, but due to lack of legal recognition, it would be dangerous for them to use. Let us jump over the electronic commerce. It eliminates the need of paper-based system. The principal hurdle in electronic commerce and the governance are two. Number one, the requirement of writing for legal recognition, and the number two, requirement of signature for legal recognition. What does it mean? In every business transaction in e-commerce, the first and foremost thing, there should be a writing, and that writing should be legally recognized. But the problem is, suppose something is available in the soft copy or in a software or in a cyberspace, then whether it is legally recognized or not. If it is not legally recognized, for example, if A purchase the refrigerator from the refrigerator shop, and he transact through online medium, then in such a situation, if suppose the shopkeeper denied that I have not received the amount, and suppose there is no legal recognition of that transaction, then definitely there will be hurdle. There would be a hurdle or injustice caused to the purchaser. In such a situation, there is need of legal recognition. And number two, requirement of signature for legal recognition. What does it mean? If someone is just signing, then anyone can morph it. Anyone can make a copy of it. So there should be a digital signature, there should be an electronic signature. Although there is a difference between the digital signature and the electronic signature, we would understand the latter, that there are two keys, the public key and the private key, that are used in this digital signature. We will later understand in section 3 and section 3A of the Information Technology Act. But by virtue of section 4 of the Information Technology Act, the all the requirement of legal recognition has been fulfilled. Similarly, by virtue of section 3 and section 3A, the requirement of digital signature or electronic signature has been fulfilled. Now, one of the very important aspects of the information technology is the law of evidence. As we know, Indian evidence law that was passed in the year 1872 is entirely based over the paper-based system. So, what does it mean that if anything has to produce before the court of law, that has to be produced in paper system or in the document form? Although we are knowing that what we call the document, there are two types of evidence: the documentary evidence and the oral evidence. And we know what we call oral evidence by virtue of Section 3 of the Indian Evidence Act 1872, that all the evidences, all the statements which court permitted to be made before it and which has been cross-examined, that is oral evidence, and documentary evidence which court requires to be produced before it, that is documentary evidence. But after the enactment of Information Technology Act 2000, the meaning of evidence has been changed, and now the documentary evidence includes the electronic evidence. Wherever the term documentary evidence is available in uh, Indian Evidence Act, one additional term has also been incorporated, that is documentary electronic evidence. So, even if a soft copy may be produced before the court of law, and all the soft copy which are produced before the court of law are the documentary evidence. For example, the photograph in the WhatsApp group, the photograph available over the website. Recently, the Prashant Bhushan has been convicted. Yesterday, the Prashant Bhushan has been convicted by the Supreme Court of India for the contempt of court. He written something over the Twitter, and thereafter the Supreme Court of India taken the cognizance, and finally the Supreme Court of India convicted him for the contempt of court, and the Supreme Court of India directed him to furnish to deposit rupees 1 as fine. If he is not depositing the fine, then he would be uh, sent to the jail with 3 months of imprisonment, and his license for practicing in the court of law would be suspended. So, even whatever the things are available over the website, whatever the things are available over the Twitter, Facebook, Instagram, that all can be considered as a documentary evidence. So, how it become a reality? It would become a reality after the amendment in the Indian Evidence Act 1872, and there is legal recognition of the electronic evidence, or the we can say the documentary evidence. The electronic evidence is now a documentary evidence. For example, in your daily life, if you are traveling in the train and you are showing the SMS issued by the IRCTC or the Ministry of Railway that this is my ticket, and the TT would recognize, and that is only uh, become a reality due to Section 4 of the Information Technology Act 2000. Therefore, due to all these hurdles, the government of India uh, realized that there is need for introduction of information technology law, and therefore uh, it makes a suitable amendment in the existing laws to facilitate the e-commerce and for legal recognition of electronic records and the digital signature. So what happened on 17th May 2000, India is the 12th nation in the world which adopt the cyber law. The IT Act, the Information Technology Act 2000, is based on model law on e-commerce adopted by Ancestral. This act, the Information Technology Act, is based on the resolution A oblique RES oblique 51162 that was adopted by the General Assembly of United Nations on 30th January 1997. It was a resolution of the General Assembly, and therefore the Indian Parliament passed the Information Technology Act 2000. on 17th May 2000. So, not only passing of this information technology law was sufficient, rather it further amended the Indian Penal Code 1860, the Indian Evidence Act 1872, the Bankers Book Evidence Act 1891, and the Reserve Bank of India Act 1934. These four enactments have been amended by virtue of Information Technology Act 2000. Further, you must know that resolution has been passed by the United Nations General Assembly that all the states gives favorable consideration to the model law on electronic commerce when they enact or revise their laws. In view of the need for uniformity of law applicable to the alternatives to the paper-based methods of communication and the storage of information. So what happened? This was a resolution passed by the United Nations General Assembly that while the countries are going to pass the law, then they must give a favorable consideration. They must revise their laws. So therefore, the Indian Parliament has revised the Indian Penal Code, the Indian Evidence Act, the Bankers Books Evidence Act, and the Reserve Bank of India Act. And also it gives legal recognition to the storage of information under the Information Technology Act. So there were four objectives of this resolution. Number one, the legal recognition to the electronic commerce. Number two, uniformity of law. So you would see in entire world those who are the signatory of this ancestral model law that there is uniformity of law. You will find there is similarity between the Indian law and the American law and the European Union law, and also it gives recognition to the paperless system and the storage of the information. So Indian Parliament has captured the spirit of the General Assembly recommendation and passed the Information Technology Act 2000. Now come to the point, the objectives of the Information Technology Act 2000. To provide the legal recognition for the transactions carried out by means of electronic data interchange. For example, there is transaction between two people, A and B, then definitely there would be a legal recognition and that was legally recognized. And other means of electronic communication, for example, a communication between two persons over the WhatsApp chat, commonly referred to as the electronic commerce. Number two, to facilitate electronic filing of documents with the government. For example, you are filing the income tax return, you are filing an application to the university, you are filing an application for the ration card, you are filing an application for the income certificate, caste certificate, birth certificate. So whatever application you are filing with the government, that has been facilitated by the electronic filing, and it is called e-governance. To amend, the third objective was to amend the Indian Penal Code, Indian Evidence Act, Banker Books Evidence Act, and the Reserve Bank of India Act, and also giving legal recognition to the storage of information. These were some objectives of the information behind the passing of the Information Technology Act 2000. Now, come to a very important aspect of the interpretation of Information Technology Act 2000, for which we must go through the Konkan Railway Corporation Limited versus the Rani Construction Private Limited, that was decided by the Supreme Court of India in the year 2002. So before that, you must know that the act is not only in tune with ancestral model law of the electronic commerce, but also to unfold the various aspects of the information technology to promote the efficient delivery of the government services that we have studied, that what we call the e-governance. Now, come to the point, the interpretation of the Information Technology Act 2000. The question is, certainly a question may come in your mind that whether ancestral ancestral model law on the electronic commerce could be used as an external aid to interpret the various provisions of the Information Technology Act, or in other words, we can say, you may ask that whether the ancestral model law can be an external aid for the interpretation of the Information Technology Act 2000 because it is based over the ancestral model law. Certainly, a question may come in the mind of the courts and in individual. So in this case, the Konkan Railway Corporation Limited versus Running Construction Private Limited, the Supreme Court of India decided and held that the ancestral model law on the international arbitration was only taken into account in drafting of Arbitration and Conciliation Act 1996. It was only taken into account for the drafting the Arbitration and Conciliation Act 1996, and it is patent from the statement of object and reasons of the act. The act and model law are not identically drafted. When you will study the Information Technology Act and the model law, then you would see that they are not identically drafted. Rather, it has taken some glimpse from the model law, ancestral model law. The Act and model law are not the identically drafted. The model law and the judgment and literature thereon are therefore not a guide to interpret to the Information Technology Act 2000 that were decided by the Supreme Court of India, since they are not identically drafted, and therefore it cannot be taken as a model law to interpret the Information Technology Act 2000. Rather, for interpreting, we must go to the parliamentary debate as external aid, and also reasons and objectives that why this particular enactment came into existence, because we are not only basing our model law over the ancestral basing our Information Technology Act over the model law. Rather, we have also incorporated the crimes, the e-governance, so most of the things has been incorporated, so model law cannot be taken into account for the construction of the Information Technology Act. Now come to the point, extent of application. That is one of the important aspect of the Information Technology Act, that up to what extent it is extended to the India. As you know that Indian Parliament passed a law called Jammu and Kashmir Reorganization Act. But before that, this particular enactment was extended to the Jammu and Kashmir by virtue of Article 253 of the Indian Constitution. We have Section 75 Clause 1 and Section 1 Clause 2 of the Information Technology Act, which provides the extraterritorial operation. Point number 3, we have Article 245 Clause 2 of the Indian Constitution, which also provides legal recognition to the extraterritorial operation of the Indian laws, that says no law shall be deemed to be invalid only on the ground that it would have an extraterritorial operation. So now come to the point. It extends to the whole of India, including the Jammu and Kashmir. It also applies to any offence or contravention thereunder committed outside of India, and that is given under Section 1 Clause 2 of the Information Technology Act, and that shall read with Section 75 Clause 1 of the Information Technology Act that it applies to the offences or contravention committed outside of India by any person irrespective of his nationality. If any person who is outside of India and targeting a computer system or computer network in India, then he shall be prosecuted under the Information Technology Act. So for the extent and commencement, you must study Section 3 and Section 4 of the Indian Penal Code, and also Section 1 subsection 2, Section 75 subsection 1 of the Information Technology Act, and also Article Article 245 clause 1 and Article 253 of the 245 clause 2 and also Article 253 of the Indian Penal Code, that you have to study, that when you will study all these sections, all these provisions, then you will get to know that what is the extent of the Information Technology Act. So what it further says, if such act involves a computer system or computer network located in India. Now come to a very important aspect of information technology, that where this particular provision is applicable and where it is non-applicable or not applicable. By virtue of section 1 subsection 4 clause A, it says nothing in this act shall apply to the document or transaction is specified in the first schedule of the Information Technology Act. So there are certain categories of documents where the Information Technology Act is not applicable. Why it is so? Why this particular enactment has not been extended to the certain documents? The reason is there must be an infrastructure. For example, there is negotiable instrument other than check as defined in section 13 of the Negotiable Instrument Act 1881, on which this particular enactment is not applicable except check. On check, because we have electronic check. In case of electronic check, electronic fund data transfer, electronic fund transfer, the Information Technology Act is applicable, but there are certain other negotiable. For example, the promissory note. On the promissory note, the Information Technology Act is not applicable because we don't have a note which is electronically available. Similarly, on the power of attorney, as defined in Section 1A of the Powers of Attorney Act 1882, the Information Technology Act is not applicable. Again, a trust, as defined in Section 3 of the Indian Trust Act 1882, on which the Information Technology Act is not applicable. Again, a will, as defined in Clause H of Section 2 of the Indian Succession Act 1925, including other testamental disposition, on which the Information Technology Act is not applicable, or any contract for the sale or the conveyance of immovable property or any interest in such property. So if anybody is selling his property, then there should be then Information Technology Act would not be applicable. Rather, there would be physical communication of the document or physical transaction of the document or any such class of document or the transaction as may be notified by the central government. So these are the list of the document on which the Information Technology Act is not applicable, but it is applicable, although it is not applicable over the Negotiable Instrument Act, but it is applicable over the check, although check is also a negotiable instrument. Hope you have understood that what we call the information technology and how it is applicable over the other documents and what are the its scope, its need and object. Thank you. Thank you very much. Another important aspect of the Information Technology Act is the overriding effect. As per Section 81 of the Information Technology Act, the Act to have overriding effect. This Act would have overriding effect, and the provision says the provisions of this Act shall have effect notwithstanding anything inconsistent therewith contained in any other law for the time being in force. So, even an act which is inconsistent with the law made under the Information Technology Act, then this particular enactment would have overriding effect, and therefore there is a term called notwithstanding. That is a non-obstant clause, and it would have a overriding effect over the other provisions of any other law. Hope you might have understood. Thank you. Thank you very much.